Welcome, everyone, to this conference put on by the Stanford Constitutional Law Center. I'm Michael McConnell. The conference today is entitled Presidents Beware, Investigations, Impeachment, Disqualification, and Prosecution. I'd like to apologize for my voice. I'm doing my best to whisper, but I hope everyone can hear me. I've just recovered from pneumonia, and although I'm not sick anymore, my lungs are still battered and my vocal cords are battered. And so if you don't hear me, please let me know and I'll speak up. But other than that, I'm going to try to protect myself. In the summer of 1973, when I was just out of high school, I was one of the presidential scholars from one of the two presidential scholars from the state of Kentucky. And we all gathered, 102 of us in Washington, shown the sights and, met people in the three branches of government and all of that. But the thing I remember best is one evening we were all in a bus, or probably several buses, but we drove by the White House. And you can picture the old executive office building, that beautiful Italianate a building right next to the White House. It was the entire facade, from the top to the bottom, the entire facade was draped in a flag of the USSR, of the Soviet Union. It so happened that Leonid Brezhnev was in town for a state visit. It was eerie. It reminds me a bit of these alternative history shows that you can see streaming on Netflix that where the Nazis won the war or the Confederates won the war, and it plays out. So it was like living in Washington under the occupation of the Soviet Union. But then what happened is that we noticed that there was a moving van that had pulled up to the White House. And guys were carrying out luggage and, filing cabinets, and I can't remember what all, but all this stuff. And, here we are, a bunch of teenagers, and hilarity ensues, because this is the summer of 1973. Nixon is still president. He has not yet resigned. And yet everybody in the bus is hoping for that day to come. And so many jokes about being here to see Nixon leaving the White House and so forth. Little did we know that just a few months later, he actually would resign. And, Nixon, the first president to be impeached, after Andrew Johnson. Right now, Nixon was not the first rascal to be president of the United States, but he was the first rascal to be impeached and then to resign, and then to be prosecuted criminally as a former president. Right, and I'm thinking of that vision of the busload of smart-assed kids as the title of contents for this conference, because we have impeachment, we have a prosecution of former presidents. Very shortly after this, Ronald Reagan will be president, and for the first time in American history, a cabinet officer will be held in contempt of Congress for refusing to comply with a congressional subpoena. First time ever, 1983. And then comes Bill Clinton, another impeachment, and we begin to look around at one another. I'm not talking about the kids anymore, but by then I'm teaching. We're looking around each other and saying, is impeachment just going to become an ordinary weapon of partisan struggle, right? it had been reserved for the most serious of things for Andrew Johnson, of all people, and Richard Nixon. But now, Bill Clinton over lying about his sex life, and what will be next? Is this going to continue to happen? And indeed, it does continue to happen. I'm not saying that I'm not judging, the seriousness of the charges, but Donald Trump is then impeached twice. So we're, the rapidity with which this is happening is rather disturbing. Meanwhile, the frequency and virulence of the conflicts between Congress and the president over investigations continue, so that every attorney general, going back to Attorney Eric Holder, has now been subpoenaed, refused to comply with subpoenas, and has been held in contempt of Congress. Every one, and now they just slough it off. It's a badge of honor. So contempt of Congress is going through an entirely new phase, and then some clever law professors, including one of my favorite former law clerks, went one day and they brushed the dust off of their bicentennial pocket copies of the Constitution and found Section 3 of the 14th Amendment that no one had ever heard of before, and said to themselves, here's a way we can keep Mr. Trump possibly the leading candidate, for more Americans seem to want him to be president than anyone else, to keep him from being on the ballot. So presidents beware. We're going to be talking about all of these issues today, and I am so grateful to the speakers who have come from all around the country. I think you will find that we have just an all-star cast of scholars and practitioners to be talking about these issues. And I also thank those of you who have come to listen. And with that, I am going to turn it over to the first panel and to Judge Danielle Forrest of the Ninth Circuit, who is the moderator of the first session. Yeah, if I collapse, my voice collapses, you can...
Okay. All right, well, while the mics are finished, we'll get started. So I am Judge Danielle Forrest. I'm on the Ninth Circuit, and I'm happy to be here with you today at Professor McConnell's invitation. I've been thinking about, I'm going to introduce our panelists so that you have a sense of why they're here to talk to you about investigations. And I've been thinking about why am I here? This is not my area of expertise at all. But as Professor McConnell was telling his story about when he was a youth, it reminded me of a story of when I was in my confirmation process. I was in Washington, D.C., getting ready to meet with one of my home senators in advance of my Senate confirmation hearing, Senator Ron Wyden. And I had sort of waiting in his office, and he was doing something important, and I'm waiting and waiting and waiting. And as I continued to wait, there are a bunch of television screens in his office, and the news breaks that Trump is being impeached. And I was sitting there thinking, this is a little awkward to be here. So I guess maybe that's my I'm here today. I don't know. Professor McConnell didn't know that story. So, all right. So many of you, or maybe all of you, know Professor McConnell. I remember him from when he was a judge on the 10th Circuit when I was a clerk there years ago, and so it's hard for me to call him professor and not judge. But of course, he is a professor here at Stanford and the executive director of the Stanford Constitutional Law Center. He's a senior fellow at the Hoover Institution. He dabbles in private practice as of counsel with Wilson Sonsini. Of course, he has taught at many other notable institutions in the country and worked in the government, in the SG's office, and in the Office of Management and Budget, argued many cases in the Supreme Court. So his experience and knowledge in this area is of course, vast. Of particular note for our topic today, he wrote a book, The President Who Would Not Be King, Executive Power Under the Constitution, which was published a few years back. Next to him is Professor Chafetz, who is a professor of constitutional law and legislation and separation of powers at Georgetown. He earned his undergrad and law degrees at Yale, and in between those two things, he was a Rhodes Scholar at Oxford, earning a doctorate in politics. From what I can tell, looking at his background and his area of scholarship, he focuses a lot on sort of government structures and particularly the legislative power, looking at both the British system and our system. And he has written tons of articles and also a book in that area called Congress's Constitution, Legislative Authority and the Separation of Powers. He clerked at the Second Circuit for Guido Calabresi and has also taught at several other institutions in the country. And then on the end here, we have Alyssa Dacunha. She's our practitioner who can give us sort of a boots-on-the-ground perspective of this issue. So she's a co-chair of Wilmer and Hale's Congressional Investigations Practice and their Crisis Management and Strategic Response Group. She represents corporations and individuals who are facing congressional investigations and inquiries, getting people prepared for testimony before Congress, having to deal with document requests or other investigative efforts against them, and sort of crisis management generally. So she definitely brings an interesting perspective to this topic, sort of working with clients facing these issues. So that's everybody's background. Our format will be, I think each panelist will give sort of an introduction of their perspective and their area of expertise. We'll do a little bit of exchange that I will direct, and then we'll open it up for questions. So we're going to start with Professor McConnell.
Thank you. Do you mind if I stand? Thank you for that introduction, Judge Forrest. So the use of congressional subpoenas against cabinet officers backed up by contempt sanctions is now frequent, entrenched, embedded, and not even really questioned. Both parties do it. As I mentioned before, every attorney general since Eric Holder has been subpoenaed and ultimately held in contempt. This even happened yesterday. So this is ripped from the headlines that the House committee voted to recommend contempt sanctions against Attorney General Merrick Garland for refusing to supply tapes of the interviews between President Biden and Special Counsel Hur. Given how frequent and normal sounding this now is, it may be surprising, but this is actually a very recent practice in American history, and it rests on a remarkably uncertain legal footing. The first contempt citation against an executive official for noncompliance with a subpoena was in 1983. Interestingly, it involved the mother of current Supreme Court Justice Neil Gorsuch when she was head of the EPA. You know, similarly, the practice of Congress, of a House of Congress, because these are not powers exercised by Congress as a whole, but rather each individual house, and it's usually the House of Representatives, of going to court to get the court to enforce a subpoena against an executive branch official is also very recent. It first happened in Watergate, but there the district court dismissed the action because it had no legal basis. But rather than appeal, Congress swiftly passed a special statute granting the court jurisdiction in the case, only to have the court deny relief on the merits on the ground that Congress had not made a, quote, strong showing of need. The practice really got underway only at the end of the George W. Bush administration, when the House sued to enforce a subpoena against White House counsel and the White House chief of staff. The district court assumed jurisdiction, ignored the lack of a statutory cause of action, declared itself the, quote, ultimate arbiter of the conflict. This is in spite of the fact that no court had ever performed this role before in American history, the ultimate arbiter, and issued an order compelling obedience to the subpoena. Now, the D.C. Circuit on appeal stayed the decision, but then the Bush administration came to an end and the matter was dropped without appellate resolution. That's really when it got going, but it didn't stop because in the very next term, exactly the same thing took place, only with the partisan roles entirely reversed. This time, it was the Republican House suing the Democratic Attorney General to enforce a subpoena, but with the same result in the D.C. Circuit. But again, the case fizzled with the end of the administration, and so no appellate final resolution. More recently, the D.C. Circuit and Bank has approved the practice, and so now it's just assumed, I think, that the two houses of Congress can enforce subpoenas in court. But let's go back to the beginning. How did we get here? If this is so recent, how did we get here? The founders distinguished sharply between ordinary legislative investigations and impeachments. Impeachments were seen as quasi-judicial proceedings. They often refer to them as judicial proceedings. Note that the Constitution refers to the Senate as the judge of an impeachment proceeding. And it was universally understood, both Federalists and Jeffersonians understood that when Congress, each House of Congress was proceeding in its judicial capacity, that they had the traditional powers of a court, including the powers of subpoena and contempt. There was no doubt that the House could compel testimony or production of documents in an impeachment proceeding once a resolution initiating an impeachment proceeding had been passed. This, by the way, is why it was important that the House of Representatives pass a resolution starting the impeachment investigation against President Biden before they were able to enforce a subpoena against Hunter Biden, right? Because until there was an actual resolution starting it was not an impeachment proceeding, and they did not have these authorities. Now, as to requests to the executive branch for information in the course of oversight and other procedures, these at the beginning were directed to the president, and while the president himself to Washington. And while he understood that it was understood that the president had a duty to provide the information, he had the discretion as to timing and could withhold documents in the public interest, as Washington and almost every later president did, usually with the acquiescence of Congress. Now, this did not mean that Congress could not compel disclosure and testimony in connection with its oversight functions, but it did not proceed by means of subpoena and contempt. Rather, it enforced its will through appropriations, refusals of confirmations, and other political means, which led to interbranch negotiations and usually to executive branch compliance, at least in substantial part. When Congress was united in support of its institutional prerogatives, these political weapons were potent. Democrats and Republicans both wanted to make sure that Congress had the tools necessary for Congress to do its oversight job. But they lost their potency when, in these more hyper-partisan times, members of Congress stopped supporting enforcement of congressional demands against presidents of their own liking. Now, it was a much contested question at the beginning whether Congress could enforce its will against non-members of Congress via contempt. Note that Article 1 has an express provision allowing each House of Congress to punish its own members for misconduct. And many lawyers believe that that meant that if you had to have an express provision allowing them to publish members, that must mean that they do not have the power to punish anyone else. Now, it so happens that there was a motion at the Constitutional Convention to expressly empower each House to punish violators by punishment. Motion was made by South Carolina Delegate Charles Pinckney. It was rejected by the Constitutional Convention. Madison and Randolph had, quote, doubts about the propriety of such a power, and Wilson said that it was, quote, needless. The first commentary on the Constitution by St. George Tucker, a Virginia jurist, said that the fact that the Constitution expressly gave each House power to punish its own members implied that they lacked the power to punish non-members, and indeed he called into question whether due process would permit punishment by a single House by a political vote. Thomas Jefferson's Manual of Parliamentary Practice, which he compiled in his capacity as President of the Senate, discussed this in several pages. He was undecided. He recited arguments on both sides of the question of congressional power to punish by contempt. The Supreme Court over about a 150-year period vacillated. They first recognized this non-textual power on the basis of, quote, necessity, and then 4 decades later rejected it, saying basically that there are no sort of secret powers that Congress can exercise contrary to the liberty of an individual. Due process clause. A bill of attainder clause. How can it be that if both houses of Congress can't pass a bill of attainder punishing someone, that one House of Congress is able to do so? But then in 27, in a case called McGrain against Doherty, the Supreme Court finally embraced this power emphatically. This is a case involving an investigation of the Teapot Dome scandal. And McGrain remains good law. It's never been, the court has never questioned it again, so it is still authoritative Supreme Court precedent, even if it is a textbook case of bad arguments and non sequiturs. But what did the contempt power mean? It meant that the House or Senate would dispatch its sergeant at arms to physically arrest the contemnor, haul him back to Washington, and lock him in the basement of the Capitol until he would then be hauled before the bar of the House or the Senate. This is still called the inherent contempt power, and Congress, the houses of Congress, at least nominally, still seem to have this power, although more recently Congress has said that this power is inappropriate, which you can see why that would be true. The inherent contempt power did not involve judicial process. They did not go to court for any authorization. There was no warrant. There was no hearing. It was just the only role that the courts ever had was when some of these hapless prisoners from the basement of the Capitol would file for a writ of habeas corpus, in which case the courts would have a defensive, a protective role, but they did not have an enforcement role with regard to subpoenas. Now, in the mid-19th century, Congress passed a statute making contempt of Congress a criminal offense. And this is how subpoenas have been enforced ever since against, gang leaders and mafiosi and suspected communists and tobacco company executives and the like, private citizens. But the criminal statute is useless as a means of compelling testimony from executive branch officials. Departments of Justice of both parties have steadfastly and invariably refused to prosecute officers from their own administration who refuse to testify or provide documents if they receive the blessing of executive privilege from the president, which they always do, even when the grounds are feeble. Just yesterday, President Biden invoked executive privilege to protect Attorney General Merrick Garland from prosecution for defiance of a House subpoena, even though the issue involved Biden's private conduct before he was president, making it an exceedingly unlikely topic for invocation of executive privilege. Now, Congress has not used its inherent contempt power since about 1940, and as I said, has called it inappropriate and unseemly. In recent times, contempt votes have become so political and commonplace that officers like Attorney Generals Holder and Barr call them a badge of honor. Criminal contempt has become a potent weapon only in the last 2 or 3 years. And that's because in the last 2 or 3 years, we've had investigations of a former administration, which is practically unheard of in American history. Usually bygones have been bygones. But President Biden has refused to extend executive privilege to Mr. Trump and his underlings. An act I predict, I don't make predictions very often, but I confidently predict that this is something he will gravely regret when the shoe is on the other foot. But he has refused to extend executive privilege to former presidents, and the Justice Department, his Justice Department, has prosecuted and convicted a number of Trump-adjacent characters. I'm not defending them, by the way, I'm just reporting the facts. The open question is whether the houses of Congress can go to court to enforce subpoenas. Congress has enacted a statute permitting the Senate, but only the Senate, not the House, to go to court for a declaratory judgment enforcing a subpoena against a sitting executive officer, but expressly excluded cases where the president has invoked executive privilege. So that is the statute on the books. Only the Senate can sue, and they cannot sue in cases where the president has invoked executive privilege. But the D.C. Circuit, sitting en banc in a case involving former White House counsel McGahn, in its wisdom, has permitted such suits by the House, even in the face of invocation of executive privilege. But my personal opinion, the reasoning was anything but airtight. Now today, subpoenas and contempt have become standard fare for interbranch warfare, for better or worse. My point is simply that this is not deeply rooted in the historical practice, has no basis in constitutional text, and is only ambiguously grounded in the law. maybe that does not matter.
Okay, so my topic is perhaps a bit more contemporary and perhaps significantly less sophisticated than Michael's. I want to talk about the January 6th committee. In some ways, it seems sort of both very much on topic for this conference and perhaps slightly off topic as well. After all, the J6 committee sought to hold a former president, among others, accountable for his actions, which is not quite the same as holding a current president accountable. On the other hand, its aims with respect to Trump were holding him accountable for actions he had taken while he was president. And to the extent that the committee's actions have an impact, they may serve as a deterrent function for future presidents. And most broadly, I think the January 6th committee made use of methods that may well continue to shape oversight of the presidency well into the future. So on the whole, I thought it was appropriate to make my focus the January 6th committee, especially as well because there's been, in my view, sort of surprisingly little scholarly literature to date on the January 6th committee. So without taking more than just a few minutes, because I think we're all anxious to get to discussion as well, I just wanted to say a bit about, first of all, how the committee was structured, second of all, how it operated, and third, and perhaps most importantly, why we might think that it mattered. So first, as to structure. The January 6th committee was a select committee, which means that the appointment of members was vested in the speaker's discretion. The resolution creating the committee called for a 13-member committee, 5 of whom would be appointed after consultation with the minority leader. Only 2 Republicans, Adam Kinzinger and Liz Cheney, voted for the resolution creating the January 6th committee. For the Democrats, Speaker Pelosi chose 7 Democrats and Republican Liz Cheney to serve on the committee, and she appointed Benny Thompson to chair. For the Republicans, Minority Leader McCarthy put forward 5 members. Now, 3 of the members he put forward, Jim Banks, Jim Jordan, and Troy Niels, had voted to reject the 2020 election results in Arizona and Pennsylvania. Banks and Jordan had also signed an amicus brief in Texas versus Pennsylvania, arguing that the results in Georgia, Michigan, Pennsylvania, and Wisconsin should be thrown out. Those 2 as well, Banks and Jordan, had also made strongly disparaging remarks about the committee itself and about the investigation into the January 6th insurrection. In response to Minority Leader McCarthy's suggestions, Pelosi agreed to name 3 of the 5 recommendees to the committee, but she rejected Banks and Jordan and asked McCarthy to suggest 2 more names in their stead. McCarthy refused, instead choosing to pull all 5 of his recommendees off the committee. Pelosi subsequently appointed Adam Kinzinger as a second Republican on the committee, and the committee roster was set with 7 Democrats and 2 Republicans. In response, McCarthy introduced a privileged resolution condemning Pelosi's refusal to seat his recommendees and urging her to do so. That resolution was tabled by a more or less party line, 218 to 197 vote. I think it's relatively clear in retrospect that McCarthy made a strategic mistake here, and spoiler alert, it wouldn't be his last strategic mistake as leader of his party. Pelosi had made it clear that she was willing to seat some very Trump-supportive Republicans, and by refusing to accept 3/5 of a loaf, McCarthy basically ensured that the committee would operate with a sort of unity of purpose that it would have lacked had it seated even just the 3 McCarthy recommendees that were acceptable to Pelosi. Now, importantly, sort of once the committee was created, it made several, I think, very significant choices about how to structure its proceedings. So first, it collected a tremendous amount of information, including a very large number of videotaped depositions, before beginning its public hearings. Second, the committee hired James Goldston, the former president of ABC News, and before that, a longtime producer at the network, to, in effect, produce its public hearings. And third, it scripted those hearings and included significant sort of multimedia elements. So the committee's authorizing resolution specifically authorized departures from the normal rule of 5 minutes per questioning per member to allow both for longer recognition of individual members and to allow for questioning by staff. In lieu of the normal sort of hearing format that we're all familiar with from C-SPAN, because I assume, like me, all of you watch C-SPAN for fun, the hearings featured sort of live witness testimony interspersed with video segments, sometimes of depositions, sometimes of the events of January 6th itself, sometimes of computer graphics designed to illustrate a point, all with sort of a committee member point person serving as a sort of narrator and lead questioner. Frequently, this role fell to Vice Chair Liz Cheney, and it was equally frequently emphasized that the vast majority of witnesses called to testify and whose depositions were shown were themselves Republicans. Importantly, sort of what all of this added up to was a process that not only turned up a great deal of information about the January 6th insurrection, but also made the communication of that information to the general public a central goal. Put differently, the committee effectively made use of what I termed in a 2020 article before the committee came into being, congressional overspeech, which I defined as the use of oversight mechanisms to communicate with the broader public. The result of the January 6th committee's attentiveness to overspeech was that the hearings made for enthralling, okay, relatively speaking, these are congressional hearings, but enthralling watching. And this was borne out by the hearings ratings. So 2 of the hearings were televised in prime time, and those 2 hearings were watched by an estimated 17.7 million and 20 million people, respectively. The viewership for the daytime hearings ranged between 9 million and 13.2 million people. Now, to put that in a little bit of perspective, Primetime's top-rated show for the last 12 years has been NBC's Sunday Night Football broadcast, which averages just under 20 million viewers per broadcast. The top scripted show in 2022 was Yellowstone, shockingly, which averages around 12 million viewers per broadcast. So in other words, the hearings were a ratings hit, right? They were performing, the primetime hearings performed at Sunday Night Football levels, and the daytime hearings outperformed Yellowstone. And of course, many more people than that would have seen clips of the hearings on the evening news or social media or read about it in various news sources. And after the hearings wrapped up, when the committee published its final report, multiple versions of that final report were sort of published by various publishers, and pretty much all of which wound up on the bestseller list. Polling also indicates that a large number of Americans were following the hearings, with some polls suggesting that 60% of Americans followed the hearings either very or somewhat closely. Okay, so even if people were paying attention, right, does it matter? Do we have any reason to think that this influenced anything in the world other than some people's viewing habits? I think research in political science gives us some reason to think that it does. So in their important book, Investigating the President, Doug Kreiner and Eric Schickler found that congressional investigations of the president systematically depress presidential job approval ratings. More specifically, looking at all congressional committee investigations of alleged executive branch misconduct between 1953 and 2014, they found that increasing the number of days of investigative hearings in a month from 0 to 20, slightly less than a 2 standard deviation shift, decreases presidential approval by approximately 2.5%. Those results were essentially the same, regardless of whether the investigations took place in the House or the Senate, and regardless of whether they took place in the context of unified or divided government. Additional survey experiments that Kreiner and Schickler conducted strengthened the conclusion that it was the publicity surrounding the congressional investigation itself, not simply publicity around the alleged executive misconduct, that drove a significant amount of this shift in public opinion. So put more concisely, we have a pretty good reason to think that congressional investigations can have a significant impact on the public's view of presidents. Moreover, we have pretty good evidence that that 2020 election deniers and candidates seen as especially close to Trump, 2 sort of largely overlapping categories, paid a significant penalty in the 2022 midterm elections. Studies have repeatedly found that Republican candidates who were either election deniers and or were endorsed by Donald Trump underperformed other Republican candidates, and this pattern held in both congressional and state-level races. One post-midterm election poll of ticket splitters found both that January 6th was an outsized issue for them, and that they had been especially attentive to the January 6th committee hearings. Okay, so to sort of bring it all home, the January 6th committee was structured largely as a result of McCarthy's intransigence in a way that allowed it to send a unified, sort of coherent message to the public. The committee itself then took care to structure its proceedings so as to send such a message. Research suggests that congressional hearings frequently do impact public opinion, And both the ratings and the polling around the January 6th committee suggest that it was very much before the public. The 2022 midterms seem to have been significantly impacted by voters' distaste for election denialism and the January 6th insurrection in particular. So in sum, it's at least plausible, and in my judgment likely, that the January 6th committee used the techniques of congressional overspeech in a manner that effectively changed the electoral landscape, and that in doing so, it made those who were sympathetic to the insurrection less likely to hold power in its aftermath. That strikes me as a fairly significant form of constraint on bad behavior by presidents and by other political elites.
Well, thank you, Professor McConnell. Thank you, Judge Forrest. It's really fun to be here. I'm going to move this up because I feel like maybe you can't quite. So as Judge Forrest said, I lead Wilmer Hale's congressional investigations practice. In that capacity, I am on the receiving end, on behalf of my clients, of congressional investigative requests. And I am going to bring kind of the practitioner perspective here. Responding to these requests is burdensome. It's very disruptive. It's time-consuming. And a lot of times that's exactly the point. I'd never heard some of the statistics you just gave us as it relates to the executive branch. In some cases, that's exactly the point, right? Driving this disruption, drawing attention to a policy issue, focusing the target of oversight on this issue, taking away from other ways in which they might spend their time. I think some of my co-panelists would probably say that's a good thing and perhaps argue for a very vigorous congressional oversight authority. I'm going to lay out a bit of the opposite case, that at least as it relates to the president and specifically the president's personal papers, Congress should actually be more limited in its ability to get these documents for both historical, constitutional, and prudential reasons. And I'm really going to focus on the prudential piece of this. In other words, my view is that the court in Trump v. Mazars did not, in fact, go far enough in curtailing Congress's authority in this area. Just to give kind of the brief backdrop of congressional oversight authority. So Professor McConnell, you walked us through some of the very earliest decades of how Congress developed its authority. For better or worse, for about the past 100 years, it's been presumed by Congress and the courts that they have incredibly broad authority to seek documents. I'm in the position, probably at least once a month, of explaining to companies why, in fact, this member of Congress that they've never heard of is sending them what is framed as a voluntary request, but is not particularly voluntary, for their most sensitive business documents. And this has been accepted. This is an outgrowth of the Article I ability to legislate under the theory that to be able to legislate, Congress needs to educate itself about the world first. There are some limitations that apply, but in practice, these are almost never meaningful limits on their authority, and they're in fact almost just discussed as theories in the case law as opposed to real limits on their authority. But what we saw in the Trump v. Mazars case, which I think actually laid the groundwork in a lot of ways and gave us some of the most important jurisprudence out of the January 6th committee. But what we saw in this case is, first of all, the court was taking up an issue that had never before addressed. It was resolving, the Supreme Court, for the first time in American history, was resolving an interbranch conflict related to congressional oversight. If you're a congressional oversight nerd, I feel like I've found my people when I'm talking about watching C-SPAN for fun. But this is a big deal, right? It almost never comes before the court. So it's a very closely watched case by many, including the Congressional Bar. Where the court landed, as most people in the room will know, is that it certainly affirmed the very broad authority that Congress has to seek documents as part of its Article I legislative authority. But it did place some limits, and perhaps most importantly for today's panel, it affirmed that when you're talking about the president, there are special considerations that come into play. This was a case where several House committees had subpoenaed Trump's financial records. They were seeking them from his accountants, which there's no real practical difference here. They were seeking the personal papers of the president as it relates to this case in particular under the legislative purpose theory, right? That this was going to, getting his personal financial documents was going to inform legislation that the committees would put forward. And again, while the court upheld this, it outlined this 4-factor test that courts would have to apply in determining whether a subpoena was properly issued by Congress, looking at, among other things, the burden that this would place on the executive. And the court left open the idea that this was not an exclusive list of factors. Basically, it's telling litigants and future presidents, you can come back and we'll look at this again. The way Roberts put it was, one case every 200 years does not give us enough of an occasion to determine all of the relevant factors that may come into play when you're talking about the president's personal papers. So in other words, the court ended up giving Congress a far shorter leash than they previously had, although of course it did affirm this very broad authority. Thomas dissented. Thomas and Alito dissented, but perhaps most relevant here for the argument I'm putting forward. His interpretation was that Congress can't get anyone's personal papers, let alone the president's. If this theory was adopted, I would be out of a job, so I'm going to say let's not take it too far here. But as it relates to the executive, he was saying that there is a path for getting these documents, but it's through the impeachment process. That's a separate constitutionally derived authority for Congress, separate from the legislative purpose. I think that makes sense for a lot of reasons. And I'll give you, I want to talk about a couple of prudential reasons. Again, I'll leave the constitutional interpretation to Justice Thomas, which I think he does very well. He walks through the historical precedent or lack thereof, but I think there's a number of prudential reasons why this is actually, this approach is in the best interest of the American people, the executive, and Congress. But just a couple of quick observations on Mazars before I do that. So obviously the conventional interpretation here is that Trump lost that case, right? It went back to the lower courts, and he did, in fact, have to turn over his tax returns. My view, as again, a practitioner here, I think everybody lost that case. This was not a particularly favorable decision for Congress. They went in with very broad authority. They came out with broad authority, but it was, in fact, narrowed. I think more importantly, big picture, all 9 justices endorsed the idea that the court could examine very, very closely the motives and purpose behind a congressional subpoena. In other words, you come out of this case with essentially a reinvigorated judicial audit authority here. That's a pretty big deal, right? Courts generally, and lower courts in particular, show a great amount of hesitancy about wading into these interbranch conflicts. And the court does acknowledge that this is a messy place for the court to be wading into and making law. But nevertheless, they go ahead and do it, right? And they send this back to the lower courts saying, you need to apply this 4-factor test, and you need to think about whether there are some other factors as well. In other words, take a very close look at what Congress sends your way. That's a pretty big deal. The other thing that happened in this case is there was a kind of a almost throwaway line where in the chorus of holding that the president would have to comply if it met this 4-factor test, they said, of course, the executive can still raise other privileges, referring to executive privilege. And they specifically note, including the attorney-client privilege. This is actually a seismic shift in what is normally a very sleepy area of the law. Historically, Congress has taken the view that it is only limited by constitutional privileges. So the First Amendment, the Fourth Amendment, the Fifth Amendment. It has always taken the view that it is not limited by common law privileges, which would cover the attorney-client privilege. For a practitioner like me, that's a big deal because it means that Congress takes the view that it can obtain my client's privileged documents. You're coming out of this case now with the Supreme Court holding that the attorney-client privilege does apply. So that matters more for me than for the executive branch, and matters a lot to corporate America. But what it does is it shows you that every time you take these cases into court, you could end up with a line here, if you're Congress, that you really don't like. There's some other lines in the case that are really quite consequential, including the court saying that Congress is not entitled to every available scrap of evidence, right? Just because you could get something under the legislative authority doesn't mean you're entitled to it. So that's a pretty big deal. And that's why I think Congress also lost this case. And I think ultimately what that'll mean is that more of these cases will be resolved through negotiated outcomes as opposed to litigation, which maybe in the end is better. But let me go back to where I started, which is why I think it's in Congress's interest, somewhat counterintuitively, and the public interest for these cases, for Congress, when it is seeking presidential papers, to actually go through the impeachment process, which on its face sounds like a much more burdensome and intrusive process. But I think it's actually important for a number of reasons. So I'll give you 5, just because I like round numbers. So the first 2 flow from the proposition that investigation is costly to governance. Again, I had never heard those statistics that Professor Chafetz just shared, but the idea that for every hearing you hold, your job approval rating is going to drop by a certain amount is very interesting. It's not really surprising, but it's interesting to hear it quantified in that way. When you are a candidate who's thinking about running for higher office, if you know that your family and that you and your family will be subject to nonstop investigations for however many years you're holding that office, that is a significant deterrent to running for office. And I think that's really not in the best interests of our democracy. It's not in the best interest of the American people. Governing is also harder. Again, sometimes this is the point, but you are taking away the attention of the executive and the cabinet to attend to these issues. Again, some would say that's exactly the point, and maybe there is an important mechanism there in terms of holding our leaders accountable, but it's a very big deal, and I think there's reasons why we should think very, very carefully before we take that step. So with that as backdrop, impeachment process is important first because it provides more safeguards to the person who's being investigated. When Congress is performing its duties under the impeachment function, it is actually performing a kind of a quasi-judicial role where it must give the officials who are under investigation rights similar to those we give to trial defendants. So the right to present their own evidence, cross-examine witnesses, raise objections, make motions. If you are, again, in the position of thinking about whether you would run for office, knowing that there are a set of protections that would apply to you if your political rivals decide to investigate you is a very meaningful protection and kind of check on that authority. The second reason is simply that it is harder. It's harder to impeach than it is to open a legislative inquiry. Any member of Congress who holds the gavel can launch an investigation under the legislative purpose inquiry authority at any point in time. Again, this is why you get members of Congress we've never heard of who chair very small committees running very, very big investigations. The committee that was seeking Trump's tax return actually does not have legislation or any specific area, does not have legislation authority or any specific policy area. It is simply an investigative committee. So it's very easy to launch one of those investigations. It's very hard to undertake impeachment. It requires both houses of Congress. It requires the entire House leadership to think very carefully about whether it wants to use floor time and resources to undertake this. And I think that is the better balance to strike in terms of balancing the intrusion on the executive branch versus the benefits on the other side here. So again, requiring Congress to think about it more carefully, I think, is really to the benefit of the American people here. The last one on the American people side of the ledger is that there's greater accountability with impeachment. This results in an actual vote. You know how your representative voted on impeachment. Representatives will pay a political price for not voting in line with how their district would have wanted them to vote. And not only that, we literally live stream the proceedings right into everyone's living room. There's absolutely no question about what's going on. There's greater visibility, greater transparency, and greater accountability. And if you're balancing this, again, against the cost to governance, why not give the American people a greater chance to see what their elected officials are doing and give them the chance to evaluate that and weigh in? The last two are on the Congress side of the ledger. And again, this is going to sound a little bit counterintuitive. But if you are a congressional staffer or a member of Congress who is thinking about launching an oversight inquiry, and you think you have found a real issue, suspicion of criminality, a real issue that requires remediation, investigation, and remediation, then if you are looking at having all of your subpoenas be taken straight to court and wrapped up in litigation for years on end, all of your investigations are going to be stymied. And this is exactly what we're seeing with this reinvigorated judicial audit right. It's an open invitation to litigants to challenge those in court. Subpoenas expire at the end of a Congress. A Congress runs for 2 years, maybe 4, and in terms of how long you might hold the gavel. And so if you want to get something done, you have a very limited time period in which to do it. And if you're going to be wrapped up in litigation, you can have all of your goals completely stymied. Going through the impeachment process prevents this kind of judicial incursion into the oversight authority that you are carrying out here. So if you actually care about an issue, if you think there's a real problem, the better way to go about this is through the impeachment process. And then the last point is simply what I said before about every time, if you are Congress, every time you go into court, you are running the real risk of coming out of there with an opinion that curtails your authority, either with regard to the issue that's before the court or in other regards, such as all of the congressional staffers who now have to fight with me over the attorney-client privilege because Congress saw fit to weigh, because the court saw fit to weigh in on that issue. So I think there might be a range of views on these issues, and I'm looking forward to the discussion.
All right, so just to pick up, to set one more sort of principle out there before we get the back and forth going. You talked, Alyssa, a lot about Mazars, and that's a case about private papers of the president. Mm-hmm. Would you talk a little bit about what the current standard is for official papers and whether you agree with that standard?
Yeah, absolutely. So the court was specifically addressing the private papers. I don't think there's much of an argument around Congress's ability to conduct oversight of, say, the executive branches. I don't think anyone's arguing that Congress should not have the ability to conduct oversight, say, of federal immigration policy or the administration of the Medicaid and Medicare programs. I think that's probably right. I mean, to the extent we're talking about holding cabinet members in contempt, I think some of the same prudential arguments would apply. But I think, at least as it relates to the official business of the government, that is a very important check on the executive branch, the role of congressional oversight.
I think there are two ways in which the official papers present a somewhat different and more difficult problem. One, you're absolutely right with respect to executive branch documents having to do with the operations of the congressionally created programs like immigration and so forth. But there's a long-standing line between those and the actual operations of the president in his personal capacity. This is one of the reasons why the action against the chief of staff and White House counsel under George W. Bush were so troublesome, because they delved into a constitutionally vested authority of the president, namely to hire and fire U.S. attorneys. And the White House counsel and the White House chief of staff are not they are not subject to advice and consent. They are purely within the office of the White House. I think there's a very good argument that Congress does not, in fact, have authority to get those documents outside of an impeachment. Again, inside of an impeachment, I think they can get absolutely everything. Yeah. And the second thing that makes it, I think, different is whether, at least under current doctrine, whether it's possible to go to court to get the documents in the case of refusal. So in the Mazars case, the accountants didn't really care a whole lot whether they gave up the documents or not. They were just custodians, right? And so if they were instructed to do it, they would do it. That is not true of the official documents of the president, where the custodian of those documents is the executive branch itself, and they're going to resist. And whether this precedent makes any sense or not, it is there's a much longer history of forcing private parties to give up documents than to force the White House to give up documents. And note that it also flips the plaintiff-defendant role, because if the White House doesn't give up documents, Congress has to sue, so they have to get the court to order the White House to do something. Whereas in the Mazars case, Trump had to sue. Actually, Trump was the plaintiff, and he was suing to get an injunction to prevent the accountants from turning over the documents. And for a variety of very deep structural reasons, courts are much more reluctant to order action by the executive branch than it is to prevent or have injunctions blocking action. So for those reasons, I actually think that official documents are more difficult.
I just want to jump in on one thing that I think has been implicit so I think one thing that we all perhaps agree about is that Congress going to courts in this context is a problem. And I think one thing that's implicit, especially in a lot of the remarks that Mike made, that I think that are worth pulling out and making explicit, is that Congress never wins when it goes to the courts. It never wins. It might get a ruling in its favor, but it never gets what it wants, because what it wants is to oversee the administration. And it never gets that, right? So the Myers and Bolton cases, right, the cases filed under the George W. Bush administration, right, those wind up getting settled in the Obama administration. The Holder case filed during the Obama administration gets settled during the Trump administration. The Trump cases wind up getting mooted by the advent of the Biden administration. If there are Biden cases, I can confidently tell you they will wind up carrying over into whatever comes next, because the Congress, there are simply too many ways of drawing these things out, right? And Mazars is just yet another way of drawing these things out, right? A 4-factor non-exclusive test, that's just a recipe for another half-decade of litigation in any individual case, right? And so we can talk about what sort of, in the abstract, a nice legal rule might be, and this is the case I have spent 15 years arguing, both in scholarly literature and with members of Congress about this. Going to court constitutes losing on Congress's part, it inevitably. And so they've got to be thinking in terms of other ways to go about this. And then this brings us back to the point that Michael made, right, which is that Congress does, in fact, have other tools that it can use, and in fact, for much of its history, sort of has used other tools as information forcing devices. But running off to the judges and saying, please tell the mean executive to stop being mean to me is not actually a good one.
And I almost wondered if this was implicit in Chief Justice Roberts' opinion, right? I mean, he talks about how, by the way, these cases almost never make their way to us because you guys work them out before they get here. But now that you're here, we're going to adjudicate it, and we're going to create this 4-factor test, and we're going to say there's many other factors that could be out there lurking. And I almost wondered if that was to discourage future cases, right? To send the message, why don't you just negotiate this next time?
All right, so let's, before we move on from Mazars, the standard is you can get personal documents of the president if you're in the context of impeachment or if you can tie it to a legislative purpose. And Alyssa sort of set out her view of that rule, and that it's not your favorite. Let's get Josh a chance to address what you think of that rule and what the rule should be in your view.
Sure, so I guess one place where I might take issue with something that Alyssa said is, it's not clear to me why you think that in the context of impeachment, they won't run to courts. So it's true that we have the Nixon case, not Richard, but Walter Nixon, where the Supreme Court says that impeachment proceedings are non-justiciable. That didn't stop. Michael mentioned the McGahn case. The McGahn case was an impeachment case, right? Yeah. It was the House Judiciary Committee seeking testimony from Don McGahn in the context of the first impeachment of Donald Trump. And what happens is the impeachment proceeding, the acquittal in the Senate had already happened by the time the district court rules in the House's favor. Then a 3-judge panel of the DC Circuit says there is no cause of action. And then the DC Circuit en banc reverses that. And then the same 3-judge panel of the DC Circuit says that there's, no standing this time. And then the DC Circuit en banc reverses that. And then the Biden administration starts, and the whole thing is mooted, right? So the fact that we do this in the context of impeachment does not change the fact that if they're running off to courts and the way that this works, it'll continue to get sort of dragged out in the same way that it does in any other context. My view is almost the mirror image of Alyssa's. I think Congress can investigate absolutely anything at absolutely any time for absolutely any reason. I think there is absolutely nothing that doesn't fall within the legitimate legislative purpose of congressional investigation. Even Congress trying to conduct an investigation into something that is patently unconstitutional, guess who has the constitutional authority to propose constitutional amendments? Congress does. So it can be justified on the grounds of making something that is currently unconstitutional constitutional. Right? So I think the distinction between legislative purpose and impeachment is sort of artificial. It's not something that I think is particularly historically grounded in the context of investigations. This idea that you need a resolution by the House to begin an impeachment inquiry is a relatively modern thing. How do you even know if you want to begin an impeachment inquiry until
It goes back to the Jefferson administration.
But it has not been uniformly followed in the cases of impeachment. There have been plenty of impeachments that have occurred without any kind of authorizing investigation beforehand.
With a political cost paid, but yes.
But I think well, sometimes yes, sometimes no. But I think the broader issue is you may not know if you want to impeach until you get certain amounts of information. Or you may think that misconduct has occurred, but it's not misconduct that would justify someone's removal from office. Right? It's not clear to me why you would want to tie your ability to get information to the beginning of an impeachment process, especially because what it would then do is incentivize the passage of a resolution beginning an impeachment process, which I'm not sure actually carries with it that much of a political cost. Right? Impeachment might carry with it a political cost, but if the idea is just passing an impeachment a resolution authorizing the beginning of an impeachment inquiry, then all of a sudden unlocks all these powers, fine, you can just rattle those off, right? Those will happen sort of as a matter of course. And then, hey, we may or may not impeach at the end of the day because whether or not we want to impeach depends on what information we've turned up. So in my view, I think this distinction between sort of this hard and fast distinction between investigations in the service of impeachment on the one hand and investigations in the service of all of Congress's other functions on the other doesn't really sort of hold water and isn't going to do any particular amount of work for us.
All right, I want to give Professor McConnell a chance to react to that. And I'm just curious if you think in Mazars specifically, because that's what we're looking at, is anybody on the Supreme Court in the neighborhood of getting this right? What is the rule that, in the world according to you, what would the rule be?
I think what Professor Chafetz is saying is entirely true as a practical matter, but not as a theoretical matter. I mean, the problem is you can describe anything as legislative. He's absolutely right about that. When the Supreme Court first approved these subpoenas, though, they believed that there was such a distinction, and they said this is permissible only, with respect to the strictly legislative authorities, and they actually reversed. I mean, they refused to uphold several subpoenas early on. This happened again under the communist investigations, not as often as it should have, in fact, but it did. But it did some. But you're right. It's an extremely difficult line to draw. I mean, my view is that the authority of Congress to subpoena and punish people with respect to legislative investigations is actually, I mean, it's very well grounded in history, but it was made up. And, the first 4 or 5 times that this happened, there was fierce resistance, even within Congress, from people who believed that they were abusing their authority and that they didn't have the right to do this. But no one, to my knowledge, I don't think there's anyone who ever questioned the authority of houses of Congress to demand information that they wanted in connection with impeachment. So one is built on the foundation of rock, and the other is built on the foundation of sand.
All right, we're going to switch topics for a second, and then we'll open it up to questions from the audience. Let's talk about executive privilege for a minute. That has sort of come up in some of the comments already, and this idea that these issues don't get resolved within the scope of one administration, and there's always overlap. And so the question is, who holds the executive privilege, and what do we do when a past president wants to assert it and a current president might not agree, and sort of what do you talk about those issues? Josh, you want to start?
So I don't think there is such a thing as executive privilege, or rather, I don't think that there should be. If we're going to talk about things that aren't there in the constitutional text, executive privilege is certainly has to be right up there. I think it might make sense to have a certain sort of background norm, but I think it's defeasible by a legitimate demand from Congress. So I would think so. I don't think that executive privilege should ever actually be a legitimate defense to a congressional subpoena. That said, if we take as given that executive privilege exists, it seems to me to make no sense at all to say that a current president can refuse to extend it to a past presidency. Because if it exists at all, it has to exist on some kind of, we can call it prudential, we can call it structural sort of reasoning, right? That you want presidents and their closest advisors to be able to sort of speak candidly without fear that this information will come out, right? Presumably that fear of sort of ruining their reputation or something like that is equally strong whether that president is still in office or not. So as a sort of secondary cut, if we're granting that executive privilege exists, it seems to me that it ought not to exist simply at the discretion of whoever currently holds the office of the presidency.
So I agree with half of that.
Which half?
The second half. But you're absolutely right. Executive privilege is made up. I mean, it's completely made up, completely contrived, which is to say it's based upon non-formalist, non-textualist, functionalist justifications, just like 3/4 of the Supreme Court separation of powers decisions, and just like the idea that Congress can subpoena to begin with. When the Supreme Court said that it was based upon, this power is based upon, quote, necessity, unquote, what they were saying is it doesn't really exist, but it should. We really think it needs it, and so we're going to make it up and pretend that it exists. So if we're going to pretend that Congress has a power, there's no reason not to pretend that there's a countervailing a power on the other side. And back at the Constitutional Convention, when Charles Pinckney moved to actually give Congress this power, Madison made a number of interesting remarks. One of his remarks was to say, and if we're going to give Congress this power, we need to give the president a privilege. And nobody wanted to get into it. It was like then the whole thing was voted down. This is just too complicated. But we don't want to get into it. But Madison realized you can't have Congress having this unlimited power on the one side without, and executive privilege has, it's true, it was just made up, but it was made up as long ago as the congressional subpoena power was made up. It's been with us for an extremely long time. Now, what is it? I mean, I do think there's some definite limits here. There can be no executive privilege with respect to non-official acts. So when Trump tried to assert executive privilege with respect to communications with people who are not officers, I think Steve Bannon, I forget
Navarro.
all these people. There was no basis for that. He couldn't do that. It's the solidest bases for executive privilege have to do putting aside national security secrets, which is really have a different history and function. The strongest basis is for the deliberative privilege that the president should be able to talk to his high-level officers and get their candid advice without everybody knowing afterwards what they say. Just like judges, we like to be able to talk to our law clerks and to our colleagues, and we should be able to say whatever we want without fear that somebody's going to find out. Congressmen can talk to their staffers. Everybody should be, I mean, this is an essential thing, but it doesn't extend. And Eric Holder, Obama exerted executive privilege on behalf of Eric Holder with respect to conversations that took place among low-level employees of the Department of Justice who are in the Office of Congressional Relations. Look, that is not covered by executive privilege. Right now, what is? It's a little. I know some things that aren't, but things that are. I think the most comprehensive description of what is covered was a memo under President Eisenhower. I recommend people to look at that if you want to see. But I totally agree with Josh. This idea that President Biden can waive the privilege for President Trump was absurd, because the whole idea that there's privilege was just made up. But it was made up for a reason, and the reason is to make sure that the president can get candid advice from his top officials. If his successor in office, which is almost always somebody from the other political party, can remove that, it's not worth the paper that it was never printed on.
Yeah, I agree with that, both as to the waiver, and you referenced the Bannon and Navarro cases, in which I think the court absolutely got that right. However you interpret and whatever your view is of the executive privilege, it simply can't extend to those cases. That said, it strikes me as absolutely remarkable that there are people, a person, sitting in jail today for having violated, for having not complied with congressional oversight, which really underscores what a truly broad power that is.
I just wanted to say one thing in response to something that Michael said. I think the one thing that's worth noting, right, is that the president only has advisors because Congress pays for them and authorized them in the first place, right? So if we're thinking about the president having some kind of constitution, I mean the Constitution's the written Constitution's executive branch is like 1.5 people. Right? It's the president and then the vice president, who the main part of whose job is being president of the Senate. Now, it contemplates that there will be heads of departments, but it doesn't specify how many or anything else about them. Right? So they're all created by statute. They're all paid for by congressional appropriation. That seems to me to make them at least partly creatures.
Law clerks.
I agree. And if Congress wants to subpoena law clerks for their testimony, they should absolutely be able to do it.
Do we agree with this?
But see, this is what happens. The judges conspire against Congress.
All right, on that note, let's open it up to the audience. I think because we're recording, you need to come to the microphones. And because I'm a judge, and this is a room of a lot of lawyers, I assume, I'm just going to say, ask a question and not give a speech, please. And so, come on up.
One here and one on this side. I thought the people were coming down. I was skipping the room. Okay, so here's my question. So this is sort of for Josh, but it's for everyone. But since, Josh, you pointed out that when these issues go to court, subpoena issues go to court, they tend to get dragged out, and so they won't get resolved until the next administration, if at all, or they're moved out, and so Congress is never going to win in court. And I take it that your suggestion is that instead what they should be doing is sort of the dance that Roberts points out Congress and the president have always done, which is to sort of compromise and work this out between themselves. But the way I view that dance is happening, and the reason it's always worked is because it's happening against the backdrop of the threat of judicial engagement and ultimately enforcement. And so what I took Roberts to be doing was trying to continue to dangle that sort of Damocles over Congress and the president, right? In the same way, right, to try to basically say, okay, this continues, keep doing what you were doing, the threat continues. But if it's true that Congress will never actually win if they go to court, why does the executive branch play the dance? Or engage in the dance, right? Why do they play the game? Why haven't they figured that out? And why haven't they just refused to comply at all?
Right, so I think you're absolutely right that that saying negotiation and compromise is insufficient because negotiation and compromise always take place in the shadow of something, right? It's some kind of distribution of authority to begin with. I think it's historically it has not been in the shadow of judicial enforcement. It's been in the shadow of other things that Congress can do. So first of all, as Michael mentioned, right, Congress does have the authority, or at least has exercised the authority since the early 19th century, to arrest and hold contemners itself. It has arrested and held 2 executive branch contemners in history. One is George Seward, who was William Seward's nephew and was the United States ambassador to China at the time. And one was what we now call the United States Attorney for the SDNY in the late 19-teens.
So not recently.
Not recently.
Not the threat that was recently.
No, but I also, so that is a sort of extreme measure, right? There's also appropriations as a threat. So this has been used recently, right? The IRS had its budget slashed by about $500 million about 6 or 7 years ago in a fight with congressional Republicans that was largely due to, what was her name, Lois Lerner's refusal to testify about whether the IRS was denying tax-exempt status to conservative nonprofits. So appropriations is another one, right? Refusal to confirm nominees is a way that the Senate can right? The Congress has a lot of sort of discrete powers that it can exercise, and I think those are significantly more potent than anything having to do with going to court, because I think it is very clear to the executive branch at this point that it can, both parties, right, that it can draw these things out in court indefinitely.
Yeah, and I think I would just add, Congress won that case, right? They got the tax returns. Since that time, Mazars has been used by the D.C. Circuit to bless various other congressional subpoenas. So they notionally won. It's been used to affirm their authority since then. I think I would just say that it's a Pyrrhic victory, right? When there's all these kind of chipping, every time you get into court, they chip away at something. It's probably still worth the gamble if you're a congressional staffer, if you're a member of Congress, to try to get into court. It's just not cost-free.
Hi there. I really enjoyed the conversation that just took place about stuff being made up. And I guess this is a question for Michael. Could Congress just give itself contempt powers and subpoena powers by statute? Or more precisely, give them to each chamber, or give them to various committees and do so under the necessary and proper clause? And if so, wouldn't we just have what we have now? And at least it wouldn't be made up.
A great question. That was another thing Madison said in this extremely brief report of a speech. He said that rather than each individual house sort of deciding on what privileges, what powers it had in each individual case, that it would be better for Congress to regularize this through the passage of legislation. And so I think the answer to your question is yes. Would it just leave us in the same place? Not if Madison's underlying logic is correct, which is that arbitrary case-by-case determinations, which vary depending on who's in power and who's not, and which are much more unfair than a regularized process might be. So we've had criminal prosecutions for contempt of Congress for these many years. It's been I can't do the math, 170 years that we've had those, but it means that people get to go to court. They can call evidence. They can raise their objections and their privilege. It's entirely different than being hauled before the bar of the House and having them just throw their politics at you.
Other questions?
My temptation in listening to this was to say what we really need is what we get in the private sector, which is mandatory arbitration. But the idea behind this is why I'm a little disturbed with the impeachment proposals. It seems to ramp up the stakes, and I have a sneaking suspicion the next panel will just say how much the stakes are ramped up. Are there ideas, and is it possible in a polarized environment to find means of ramping down the stakes to maybe sort of have an understanding there's a subpoena? It's a quick judicial hearing. By the way, nobody gets thrown in jail. We reach an impasse. On Tuesday, the judge decides on Thursday, because the issues are not that complex in many ways. So just thoughts of how we might ramp down.
It's a great question. That probably is the million-dollar question in American politics today. What I would say is I actually view applying the impeachment standard as a ramping down because I think they would be less frequent. I think there would be more protections involved. I think they would be better considered. And I think there would be real accountability, right? So if you have to use the resources of the House floor to conduct your investigations, you're not going to do it as frequently. In Trump v. Mazars, I think there were 3 separate committees that had launched investigations of the president. I think it was Ways and Means, Financial Services, and Oversight. And there's just no chance that that would happen when you're talking about the incredible amount of resources and time involved in an actual impeachment inquiry. There's votes involved, so there's greater accountability. I think for one thing I'd say in response to what you said earlier, Professor Chafetz, is you could get, I think, everything but the presidential papers in that kind of legislative purpose inquiry setting. I think there's only a certain set of papers that would be kind of off limits. And I think that's what you saw in the Nixon cases, where Nixon only had to comply with the subpoena that came through the impeachment process in turning over the tapes, not the one that came out of the legislative purpose inquiry. So I think it's a great question. I would love to hear other ideas from the other panelists as to how you ramp this down. Maybe the next panel will answer the question. My answer is simply that I think there would be fewer investigations, less politicization, if you had to take on this incredibly monumental and weighty process to do it.
I guess two thoughts. I guess I'm still a little confused about, maybe I'm just confused about sort of exactly what you're proposing, like when the House would get access to this information in the impeachment process. Because if we're talking about all you need is a vote on the House floor to authorize an impeachment process, right? That you can get through. If the Speaker is willing to declare it an emergency in an hour and a half, if not 2 days, right? To start the inquiry, and then everything happens in the Judiciary Committee. So how different is that than the Oversight Committee in terms of what's going on there, right? It's still sort of happening in committee. It's still, the procedural protections are whatever the House chooses to grant, not anything that's going to be sort of enforced from the outside, right? That is United States versus Nixon. So I guess I'm still confused as to how the impeachment process sort of makes this either better or even sort of less frequent. On the broader ramping down point, I guess I see the fights in our political institutions right now as sort of epiphenomenal of our political situation as a society. So I'm not sure there is an institutional way to ramp down. Problem is us.
It's probably true.
Oh, but can I pick up on Professor Graber's question? Because he outlines like a stripped down way to get before courts quickly with a judicial answer. Mm-hmm. Your work has been, one of the main themes of your work about this has been the undesirability of having all of this decided by courts. So I'd like to hear your response to Mark.
Sure. So I'm skeptical of the premise, right, that they actually would get that there's any procedure that they could come up with that would result in a relatively quick resolution, right? All attempts since 1972 have failed. So I'm not sure why what we would come up with that would suddenly succeed. That said, I also think there's a broader theoretical point here. I think there's something really not only unseemly but truly detrimental to Congress as an institution to have it say, well, our subpoenas are just pieces of paper, but if we can run to one district court judge and get them to say, you must comply with our subpoena, now it's something, right? So, the 435 members of the House who cares? One pissant district court judge, now we got to do it. That strikes me as a sort of willful surrender of congressional power that's part and parcel with a lot of the ways that especially over the second half of the 20th century, right, our broader political culture has become more juriscentric. And I think that is sort of detrimental to Congress. I think it's detrimental to the American public at large. So even if I were confident that we could come up with a procedure that would get us to a relatively quick, frictionless judicial resolution of these fights, I wouldn't want it.
Want to add anything there?
I'm curious how timeless our approach to this should be. So we've talked about grounding a variety of the different issues that are at play in a kind of functional analysis. And there might be, over time, massive changes in political norms or the speed with which the judiciary is able to intervene, or a la Justice White's dissent in Chadha, the separation of powers balance being adjusted over time with respect to Congress and executive power. If we keep it in flux, maybe we respond over time to the ways that the rebalancing might be, the functional analysis might play out, and yet maybe that creates some doctrinal difficulty that exacerbates the problems that Josh is talking about. So I'm curious how the sort of timeless versus in the moment functional analysis ought to play out. Thanks.
I feel like that's a question for Professor McConnell.
Wow, that's such a thoughtful question. Mm-hmm. One of the problems with judicial decisions and due to precedent is that they do get very sticky. Of course, the court reverses itself when it wants to, but it doesn't want to very often, and so we get answers, and then we just keep getting the same answer over time. And so I don't actually think that a judicial solution is very amenable to this kind of thing. Although I'm now going to say exactly the opposite, which is that maybe judicial decisions are always, one ticket, one ride only, because what a lot of these subpoena issues come down to is a balancing of the need that Congress has shown against the interference that it's going to be with the president's deliberative processes. And those are extraordinarily subjective questions of a highly political sense, and both in the sense of a political question doctrinally, but also in the colloquial sense of political. Somebody who's skeptical of the value of President Trump reaching a good decision is not going to think that it's that important for President Trump to be able to get advice from the kinds of cockamamie characters that he tends to put around him, and so that'll get a low score. But when we elect, Barack Obama, my goodness, let's be sure that the presidency is insulated from all this. So either the judges are going to have actual rules, actual standards that are going to be inflexible, or they're not, or they're just going to be deciding things on a case-by-case basis. And if we're going to have political decisions, I guess I think I'm like Josh on this. But political decisions, I'd rather be made by political people who have politics on their written on their T-shirt.
So we have a couple more minutes. There's one other question I didn't get to. So under the Mazars case, it is going to courts if it gets there. And we have this balancing test, and we're trying to figure out is there a sufficient legislative purpose. So sort of in self-interest as a member of the courts, what do you think that we're supposed to look at in figuring out what is a sufficient legislative purpose? And what standard of review do we apply to that? De novo? Clearly erroneous?
Well, just all you have to look at is it a Republican or a Democrat?
This is one where I have to very reluctantly agree with Professor Chafetz that I think that power is incredibly broad. Can you think of a time that the court has limited on that basis? I mean, it's...
On lack of a legitimate legislative purpose. There's the Kilburn case from the 1860s.
But
that's a terrible case.
I think there was one case in the late 50s.
Yep, there's
one of the communist cases.
Yeah, one of the HUAC cases. And the Kilburn case, so one of my colleagues has a great article coming out about the Kilburn case, which points out all the ways in which it's actually all about federal power, and therefore completely wrong.
I like the Kilburn case.
Right, so you've got these limitations that are discussed almost in the abstract, like it cannot be for law enforcement purposes, cannot be to expose, but the court's never actually, no court, I think, has really ever applied those in the modern era to limit congressional authority. As to the standard of review, no.
Well, and you have questions like, well, what do you do when there's an obvious political motive? Yesterday's statement about invoking executive privilege, the only real argument that President Biden offered is that the House has a political motive for wanting to get this information. Well, of course it does.
Mm-hmm. What's wrong with that?
It's like everything either House of Congress has ever done, there's a political motive. But I also worry that if the courts sort of start sniffing around and they say, well, I think this is just a pretext for politics, I just don't think they can do that.
Well, and I think this ties into something that's even in this short time you'll have realized is a hobby horse of mine, right? Which is that I think that when judges look at Congress, they are looking at it through a juriscentric lens, right? And so describing something as a political motive is meant to be a pejorative when John Roberts says it. Which, first of all, the idea that anyone would ever be on the Supreme Court without being a supremely political actor is ridiculous. But second of all, it's this idea, right, that there's something degraded about politics, right? That law is good and pure, maybe policy is fine, but politics is the bad thing that we don't want to be going on. That's nonsense. Politics is how a self-governing people rules itself, right? And so the idea that a political motive would be a reason to deny Congress something, again, I think just goes to how blinkered the courts are when they look at representative elected institutions.
And you actually see this in the January 6th jurisprudence, which is a number of litigants put forth the idea that look at all these statements made by the members, making clear this is a purely political exercise, and the courts roundly rejected those claims. Essentially said it doesn't matter what the members say. We're examining, we're looking. If we can find a legislative purpose, then we're going to uphold it.
All right, I think we're out of time, so thank you, panelists, and thank you for the questions.